featuring candidates for 14B District Court. The candidates will be on the ballot. They're not on the primary ballot. They'll be on the general election on November 3rd. Is that correct? Yeah. Okay, thank you. This year, the League of Women Voters is celebrating 100 years of expanding voter rights, educating voters, and shaping and influencing legislation at local, state, and national levels. We are pleased to co-sponsor these forums. The League is a nonpartisan civic organization that works to increase understanding of major public policy issues to strengthen and broaden knowledge about our form of government and democracy. While the League does not support candidates or parties, we do take stands on issues we have studied. One of the League's most important goals is to assist voters in making informed choices at the polls, and thus we bring you tonight's program. Our moderator this evening is Elizabeth Jolliffe from the Washtenaw County Bar Association, who will explain the format and get us started. Thank you, Elizabeth.
Thank you, Carolyn. It's my honor to introduce the two candidates running for the 14B District Court, Magistrate Mark Nelson and Ms. Irene Washington. Thank you both for participating tonight. The forum tonight will have this format. Each candidate will have an opening statement of up to 1 minute, and each candidate will have a closing statement of up to 90 seconds. In between, I will ask questions which came from the Washtenaw County community. Each candidate will then have 2 minutes to respond to a question. At appropriate times, a sign on the screen will indicate the time remaining, 30 seconds, and then stop. If you have used up your time, you'll be allowed to finish your sentence or thought, and then your microphone will be muted so that the other candidate has an equal opportunity to participate. The candidates will begin speaking in alphabetical order, and then we will alternate. Both candidates will have an opportunity to be the first or last to answer the questions. We're now ready for your opening statement, Mr. Nelson.
Good evening. My name is Mark Nelson. I'm the Magistrate and Court Administrator serving the 14B District Court in Ypsilanti Township. I've served as magistrate since being appointed by Judge Pope in 2009. I'm also the Court Administrator, having served in this role since 2012. I'm running to continue to serve the people of Ypsilanti Township as the next judge of the 14B District Court. It is my goal to continue the legacy of excellence established by my friends Judge John Collins and Judge Charles Pope. As a lifetime resident of the community, I'm invested in the positive outcomes for our community. In 1989, graduated Ypsilanti High School. My wife Carrie and I have resided in Ypsilanti Township for our entire married lives, and my son attends Lincoln Schools. I'm in my 12th year presiding over courtroom hearings as a judicial officer. I have a track record of service from the bench, and I'm ready to be the next judge for the residents of Ypsilanti Township on day one. Thank you.
Thank you, Mr. Nelson. Now, Ms. Washington.
Thank you so much. Good evening, everyone. My name is Irene Washington. I want to first thank the League of Women Voters, the Washtenaw County Bar Association, and the Dispute Resolution Center for putting on this program. I'm a mom, grandma, and I've been living in Ypsilanti Township for the past 26 years. I'm a first-generation college student, graduate, and also a University of Michigan Law School graduate. I've been practicing law for 27 years. I have 20 years of litigation experience, trying everything from trespass to murder, and I have 7 years of court administration experience. I'm the only candidate with extensive litigation experience, practicing in front of every judge in this particular county and judges in other counties. I have a vision for this court to bring mental health, restorative justice, transparency, and to build collaborative relationships with people in our community. I'm endorsed by the Chief Judge of the Supreme Court, Judge Bridget Mary McCormick, and 200 other individuals. Thank you.
Thank you, Ms. Washington. Thank you both. Now to the questions. As a reminder, I will be reading the question once and it will not be repeated unless requested. And each candidate will have up to 2 minutes to answer. To begin tonight, we will start with Mr. Nelson for the first question. The first question has to do with evictions. Yesterday, the governor's emergency order staying all evictions in the state ended. What will be your approach to eviction cases, and what, if anything, do you think the court can do to help with what many think will be a very significant problem in the community?
Thank you, Elizabeth. Yes, as indicated, we've been under an eviction moratorium for a number of months now, just ending yesterday, although that's just a partial end to it. We still have a number of rental units in the township that are still under eviction moratorium under the CARES Act, and that'll expire here shortly as well. Judge Pope and I have been working with our local stakeholders, including the other judges who handle eviction cases in the county, the legal services, our local HARA, who will be providing eviction assistance, diversion assistance under the state program that's been put out there. The county has received over $1 million in funding to assist tenants with eviction assistance. And the hope is that we'll be able to stem that tide and keep a number of people in their housing rather than create a housing crisis that is there for us. We want to make sure we're doing this carefully. The state court administrator has laid out a number of steps to ensure this is done as smoothly as possible. Starting with staging the cases in a case age order. So the oldest cases will be heard and cleared first, and then we'll proceed through the newer cases. We've also been working closely with the landlord bar, so we're getting input from all parties and all sides on these matters. And we're actually are hearing some okay news that a number of the landlords do have their rents are being paid, so we may not be facing the potential crisis that we could have otherwise faced. But it certainly will all come down to working in partnership with all the stakeholders and making sure that this landing is soft as possible for everyone involved, especially those tenants that will be affected by this.
Thank you, Mr. Nelson. Same question for you, Ms. Washington.
Thank you, Ms. Jolliffe. I believe that we are at a state of situation that's going to be very dire for many people. I think that in order to address that situation, you have to have working relationships with the stakeholders who are involved, including legal aid and the landlord associations. There has been money that has been provided. I'm hopeful that the landlords will take advantage of applying for some of the funding that has been provided by the governor in order to try to actually keep some people from actually going into the landlord system. I have worked with landlords on occasions, and I've worked with tenants in many cases in order to bring these types of cases before the court. I think that the court has to extensively look at how the staging is going to work, make sure that the cases that are before them are the appropriate cases. So the first thing that needs to happen is that if there is federal funding for those cases, they should not be there. So we got to make sure that happens first, because the moratorium is still in effect for those particular cases. We have to go back and look and make sure that the proper steps have been taken in order to make sure we're protecting the tenants when they actually come into those courts. And the legal aid that is set up right now, they've developed a checklist that we got to ensure is put into place and that all of the tenants are using those particular checklists. I think that as the court, you have to be very careful. Thank you. I'm sorry. You have to be very careful as to whether or not the people that are coming before you actually are supposed to be there at that particular time. I'm sorry, I got thrown off because she put up the stop sign that should have been the 30-second sign. But I think that the best way to do that is to make sure that everybody's heard and that we can make sure that the actual process that was supposed to occur before now has occurred, and that people get the resources. I helped to set up Ipsy City's process of making sure that there's funding through the barriers with the United Way program. So I think those are some things we have to do, is make sure resources are available.
Thank you, Ms. Washington. Our second question concerns bail. And Ms. Washington, you'll answer first. Core Rule 6.106 contains the standard for setting bail and bonds, requiring the judge to determine if the defendant is a danger to the community and/or a flight risk. What factors or screening tools will you use to determine whether someone is a danger to the community or a flight risk?
I think that's an excellent question. Some of the factors in what's going to inform my decision is my 20 years of litigation experience in which I have represented the underserved population in these particular types of cases. I've also represented survivors of these types of situations. I think that hopefully we will have it in place really soon, is the lethality assessment when it comes to domestic violence situations. We just had a issue yesterday where someone lost their life in a murder-suicide situation, and I think that those lethality factors are going to be really important in helping to determine whether someone is a flight risk or a danger to the society. And I believe that you need someone who has the experience from having tried cases over and over again, or having defended and represented people in order to know whether someone is a danger or not. You have to use wisdom and discernment in order to know whether someone actually is a flight risk. You have to look at their past behavior, but that is not always indicative of whether or not a person is going to be a flight risk in the future. You also have to take into consideration other factors, such as whether or not they've shown up to court, have not appeared before judges in the past, and you have to listen to the people that are standing before you. So it's a matter of taking the holistic approach to it to determine whether someone is going to be a flight risk or they're going to be a danger to society. And so those are all the factors those are a majority of the factors that I would look at, and each case should be looked at on a case-by-case basis. There is no cookie cutter approach to this. It has to be looked at on an individualized person-to-person situation.
Thank you. Mr. Nelson?
Thank you. So yeah, I've reviewed and set bail in cases virtually every day for the last 12 years. Today we didn't do it because we didn't have anybody arrested last night in Misdemeanor Township, but I do this daily, and I'll be doing it over the weekend. And as you indicated, the court rules do indicate that there are the factors that we need to take into consideration are dangers to society and the likelihood of appearance. And really the main factor for us in making that determination is danger to society. You have to make that determination based on the information you have before you. We have a public defender available at each and every arraignment to provide us with some information from the defendant's point of view. We do get some information from community corrections that provides us with some additional information as to prior drug use, prior case histories. Of course, we have their criminal history in front of us, but none of those are indicative of the day we're seeing the person in, the situation we're seeing the person in. When bond is set, it has to be set in the least restrictive means to ensure public safety, ensure appearance of future court dates. So in the vast majority of cases, that means the person's not going to stay in jail until their next court date. The risk to public safety is a fairly high bar, and there are a number of tools available to us as judicial officers to determine, to ensure public safety other than jail. And we need to make sure that we're taking those all into consideration, whether that be reporting on a periodic basis, whether that be being held subject to tether, whatever the case may be. You need to ensure that you're using the least restrictive means, but you have to balance that with the safety of society and ensure that those decisions are made to ensure both appearance and public safety. Thank you.
Thank you. Our next question concerns specialty courts. Mr. Nelson, you will answer first. Across Washtenaw County, we have numerous specialty courts, which are also sometimes referred to as treatment courts. These include sobriety court, mental health court, veterans court, street outreach court, a juvenile drug court, and a domestic violence court. In 14B District Court in Ypsilanti Township, there is a drug court. What additional treatment court do you think is most needed next and should be developed in 14B? And what steps will you take to make that happen?
Thank you. So as you mentioned, we do have our drug court, and we're very proud of that drug court, and we do hard work to ensure that the participants of that drug court are getting the services needed. I think that the best thing for the community is to ensure that those services continue and the drug court continues. All of these courts you've mentioned, each and every single one of them is funded by grant funds that each court has to apply to the state of Michigan to receive. And one of the factors that's considered when they're awarding grant funding is the proximity of another specialty court nearby. So when we have specialty courts in the community that are accessible and available to people, then they can utilize those courts. For example, we often send people to Veterans Court in Ann Arbor, Mental Health Court in Ann Arbor, Sobriety Court in Ann Arbor. And while not a perfect solution, of course, sending folks from Ypsilanti Township across to Ann Arbor to be seen in court hearings, a number of those grants do provide transportation, particularly with veterans in mental health court. Transportation is available through either their insurance or their benefits. And of course, the great field leveler has been the COVID virus. We're doing all of our hearings via video now, so each and every one of our participants are participating in their hearings and their review hearings via video. So that really took care of the transportation issue. I partner quite well with the other judges at the specialty courts. I speak with Judge Valvo frequently when we're referring people to mental health court and to veterans court, and we want to ensure that those partnerships continue to make sure that the resources that are available to us from the state continue to be available and are allocated across the county, and we're able to refer individuals to each of these important courts that we have available to us.
Okay, thank you. Ms. Washington?
Thank you. I think this is one of the biggest differences that we have with respect to what we think should happen in 14B District Court. I believe that mental health court is the most important addition that we need to have in 14B District Court. We recently approved a millage in this county. That millage provides funding to the community mental health. And there is the CARES program, which addresses needs for people here in the 48197, 48198 area code. The research has shown that 49% of the services provided by the CARES program through community mental health is from the 48197, 48198 area code. So 49% of the services being used is from this area. There has been a lack of mental health services to this community for a very long time. There is 55,000 to 57,000 people living in Ypsilanti Township, but yet we're using 49% of the services when we are only 16% of the total county. So that shows that there's a need there. The tactic that I would use is there are grants that are available through the Bureau of Justice Assistance that don't have those same types of restraints that are currently set up by the state. I would be applying for those grants in order to get funding so that we can have the services that we need over here on the 48197, 48198 area code. I believe that we need to get to the root causes of what's ailing this community. We have a 63% recidivism rate, and we need to address substance use disorders, so that needs to stay in place, as well as add a mental health component to the court here in 14B District. Thank you.
Thank you. I know technically we only have about 8 minutes left, but I would like to try to get 2 questions in if we could, because we've really only covered 3. So if you can bear with me, and people tell me to stop if I need to stop. Our next question, Ms. Washington, you'll take first. It has to do with people without a lawyer. District courts are often referred to as the people's court because so many people appear before the judge unrepresented by counsel. What procedural safeguards and judicial approach will you bring to dealing with people in court who don't have a lawyer?
Thank you, Mr. Olive. Having represented clients as an assistant public defender for about 7.5 years, I ran into that quite frequently where people had not had attorneys. There also was that situation when I worked for the judge. I was a judicial attorney for another 7.5 years. And there were tons of people who came through the court system that did not have counsel when they came through the courts. So the first thing you need to make sure is that they have a full understanding of the fact that they are entitled to counsel, and allow them that opportunity if they want to actually get counsel. That's going to happen at their arraignment period, obviously, and many people do qualify to have counsel through the public defender's office. And that's especially important now because we have the Michigan Indigency Defense Council that has set up that service. In the event that they are not able to afford their own counsel, then the safeguards I would put in place is to ensure that I am providing and that staff is providing them with the actual procedural guidelines in terms of what they need to be doing, not giving them legal advice because they can't give out legal advice, but to ensure that the procedural safeguards are at least told to them when they're in the courtroom. And additionally, I believe that there needs to be access to the actual court system. I think there needs to be a kiosk out front so that we can provide access to justice for those people. And we always talk about these things in the context of the criminal arena, but it's also true in the civil arena. And we need to ensure that people have limited scope opportunities if they want to hire people for a limited time period, and then they can actually do that and the attorney can go off the case and then they can come back on. So giving people who don't have the funds to have counsel is extremely important, and I think ensuring that they're listened to and heard in the courtroom is the best way to make sure that that happens.
Thank you. Mr. Nelson.
Thank you. As magistrate, when I do arraignments, we have a public defender available at arraignment, and we appoint on every single appropriate case. So the criminal side of things is well taken care of now that the Indigent Defense Commission rules have been implemented and are funded, which was a little bit long coming, but the state finally provided the funding for it, and we were able to do that. So that is very important. It's a cornerstone of our legal processes that both sides have to have representation in criminal matters, especially when there's a possibility of incarceration as a result of the case. The vast majority of the defendants that come before the courts, 14B District Court, coming out of our zip codes of 48197 and 98, qualify for the public defender to be appointed to represent them. Even those that don't qualify, or if in the rare case where public defender is not appointed, public defender is still there at arraignment to assist them. We're doing all of our arraignments now via video. So I have a public defender come in via video every day, and they're able to talk to the defendants. We put them in breakout rooms if needed, and provide the assistance through the arraignment process, explain that to them. And that's makes that whole process much better understood for the defendants, and is a fairer process for them. And as I said in my question about bond, we certainly are getting better information when setting bond because of that process. It's been in place now for a few years. On the civil side, absolutely correct that we need representation there as well. As we've talked about in landlord-tenant cases, the legal services is partnering with us to ensure that representation is available for the upcoming potential crisis we're going to have with landlord-tenant cases. And we always provide resources, whether it be legal services or contacts through the county bar, referral program, or other programs out there that are lower no-cost services to defendants. We always make sure that they're aware of those services and are engaged with those services. Thank you.
Thank you. So this will be our last question, and it has to do with restorative justice. We hear a lot about restorative justice in elections this year. What is your definition of restorative justice, and what steps will you take to implement it in your misdemeanor criminal docket? Mr. Nelson.
So you're right. Restorative justice is mentioned quite a bit, and is something that's talked about quite a bit, and does have an appropriate place in our systems here, and is utilized in Washtenaw County. To me personally, it comes down to hearing from all parties, hearing what is needed to make amends if they're possibly made, if in appropriate cases are there to be made. We have so many parties and so many interests coming before us as judicial officers in the court. We of course have the defendant in front of us. If it's an assaultive crime or a property damage crime, we have a victim who's a citizen. We have then of course the public at large as represented by the prosecuting attorney in the interest of the people. So I think the most important thing we can do is hear all of those interests that come to bear before a case, in a criminal case, and ensure that the remedies being fashioned are taking care of those interests, and those interests are addressed in an effective manner. Of course, with misdemeanor cases, we need to make sure that we're utilizing our resources and ensuring that the court resources are used appropriately. So we need to make sure we can find services that are out there and available to folks, whether it be community service, whether it be utilizing the dispute resolution center in civil cases to come to an understanding amongst the parties. But as I said, it really comes down to if you're dealing with people on that sort of one-on-one basis, hearing the issues and making sure that we were fashioning results that are beneficial to all of the parties and the disparate interests that are there. Thank you.
Thank you. Ms. Washington?
Thank you so much. To me, to answer your question, restorative justice is the process by which we determine what the harm is that has occurred, whether that's to a particular victim or whether that's to the community at large. We take a look at that harm, we take a look at the offender and figure out exactly where the offender went wrong, what we can do to make amends for that harm to the community or to the particular victim, and sometimes it's both. So in order to do that, you have to take a holistic approach at the community issues as well as the offender issues. And you have to say, what is the root cause of this person being here? And what is the root cause of this particular situation coming up this time? And that can look a couple of different ways. As you are aware, there is the peace circle where people sit around and they actually talk about the issues in a circle and decide what they want that outcome to look like. It gives the opportunity for the victim and the community, if it's a community at large situation, to try to come to some type of a resolution that makes everyone feel like they're okay and that they're reaching some type of holistic approach to solving the problem. I think this is how we get to the 63% recidivism rate that we have in the county. This is one of the ways that we can address that. So, in the criminal justice arena, I think we have to be very careful as to whether or not we're using it in cases in which there are assaultive issues and whether there's a power dynamic going on that can't be used in those particular situations. But in most situations, we can use that restorative justice process. And I think the Dispute Resolution Center has been doing a great job with that. And I would like to keep them involved in that particular part of the process. And in other civil cases, that can happen as well. I've actually been a mediator for those types of cases. Thank you.
Okay, thank you. Now we'll have our closing statements. Mr. Nelson.
Thank you all for the opportunity to speak with you today. I especially want to thank the voters from Ypsilanti Township who took the time to come and learn about this important race. I'm Mark Nelson. I'm running to be the next judge of the 14B District Court serving Ypsilanti Township. This is an open seat due to the retirement of my friend and colleague, Judge Charles Pope. It has been my privilege to work with Judge Pope on a daily basis for the past 12 years, and Judge Pope has endorsed my candidacy. As a one-judge court, the need to have a day one ready candidate is very important. I am prepared to sit as judge on day one. My experience is unmatched. I have a track record of service both to the 14B District Court and to the Ypsilanti Township community as a whole. In addition to being a magistrate, I've been the court administrator for the past 8 years. This means I know every aspect of the court's operations, from our employees to budgeting to what the court's obligations are to the state of Michigan in operation of a court. This is all experience that nobody else has. This is going to matter to ensure a smooth transition from Judge Pope's tenure. Thank you to the League of Women Voters, the Washington County Bar Association, and Dispute Resolution Center for hosting us this evening. Elizabeth, I appreciate your moderating and our discussion. I appreciate everyone's time and those of Ypsilanti Township residents. I hope I'm able to earn your vote this fall. You can find out more about me at marknelsonforjudge.com. Thank you.
Thank you, Mr. Nelson. Ms. Washington.
Thank you very much. These are unique times in our American history and in our local history. There is an outcry for reformation of our justice system, including our criminal justice system. There are two extreme and diametrically opposed positions happening at the same time from different aspects. And whether folks like it or not, there is going to be a change. Times are changing at this point. We will have a new prosecutor and new additions to the local bench. Ypsilanti Township needs change as well as the judicial system does. It is not separate from that. We don't need the same there anymore, just like we don't need it the same in the rest of our county. And I'm the person to bring that balance to Ypsilanti Township. I have a vision for the court that involves mental health components, restorative justice components, and continued substance use disorder, as well as building collaborative relationships so that we can address the issues that are the root causes of recidivism in this side of the county. Experience in criminal justice is important, and I have that. There is wisdom, life experience, and trial experience that is needed to make the tough calls when a person comes into the court as to whether they committed a crime or whether or not they are a danger to society. I am the person that brings that experience at no level that no one else has as a candidate in this particular race. I've been endorsed by Supreme Court Justice Bridget McCormick, Chief Judge Carol Conkey, the sheriff, 4 of the countywide elected officials, 200 other endorsers asked me, as well as women lawyers, highly recommended. Thank you. Vote for Irene on November 3rd, please.
Thank you. Thank you both for participating in our forum tonight. I wish you both good luck. And now I'll turn this back over to Carolyn for our closing.
Thank you. The League, the Dispute Resolution Center, and the Washtenaw County Bar Association thank the candidates for participating in tonight's forum and to those who contributed questions in our community. All our candidate forums will be available for streaming on your computer or smartphone. Go to our website, lwvannarbor.org, and look for the link to the programs. In addition, the forums can be viewed on CTN Channel 13 and at the DRC Facebook page at Dispute Resolution Center A2. Please urge your friends and fellow residents to watch these forums too. For additional nonpartisan information on candidates and ballot issues, go to vote411.org. The League's voter resource guide covering local, state, and federal candidates and current proposals that will appear in your ballot. Now, I just want to make a note. We have sort of 3 reminders, and I just want to confirm that these 2 candidates will be on the November 3rd election ballot. Correct? Yes.
Correct.
Thank you. And other reminders, all voters are now eligible to cast an absentee ballot. In addition, while voters are encouraged to register ahead of time, Michigan law now provides for same-day registration. So just remember, no matter how you do it, make sure you vote in the November election, of course, and also the August 4th primary election. Thank you very much to all of you. Good night.